basically what you need to know before I start is whether you have an individual health insurance policy that you completely pay the premiums on, whether you have a group policy that your employer pays a portion of the premiums, you pay a portion of the premiums, and your claims are being reimbursed by the insurance company itself, or whether you have a self-funded policy which is through your employer, but the employer is the one who reimburses you for your claims. Yes. Medi-Cal is kind of its own, since it's a government plan, it has its own section. Okay? I mean, it also has its own appeal process and things like that, which we'll get into in a little bit. So if anybody has any questions right now about the type of policy that they have, it might be beneficial for you to ask now before I start. Yes. Okay, so if you have a Kaiser Insurance, you have an HMO, which is, it's through your employer, so you have a, it's going to fall under, well, we'll talk about that later, but you have a normal insurance policy through your employer, not a self-funded policy, okay? Anybody else? Okay, then we'll go ahead and start. Like I said, there are 3 types of policies. The first type is an individual health insurance policy. This is the type that you you pay the premiums completely on your own. So it is not part of an employee benefit plan. This type of policy is subject to California law, which is contained in both case law and in the California Insurance Code. And when we interchangeably use the terms insurance policies and HMOs sometimes, and really an HMO is not an insurance company, if that makes sense. A lot of us say, oh, my insurance company is Kaiser. Well, if you have Kaiser, it's technically not an insurance company. But to make things, and you'll see why that's important later, but to make things easy for right now, most of us use the term insurance company as meaning, HMO or an insurance company. So if you have any questions about that, yes.
I actually have a question. If you are about to go on COBRA, are you considered 1 or 2?
It depends what the original policy was. Was it through an employer?
Yes.
Then it is still technically through the employer. It's that type of policy. Because basically it's just a continuation of that policy for the time being. Okay? Okay. So back to the individual health insurance policies. These are the ones that you pay the premiums on completely on your own. This is mostly if you're if you don't have insurance through your employer. So HMOs are regulated by the Knox-Keene Act, which is contained in the California Health and Safety Code. So what do you do if you have an individual health insurance policy and your claims are wrongfully denied? HMOs are regulated by the California Department of Managed Healthcare. They are always regulated by the California Department of Managed Healthcare. They are not regulated by the Department of Insurance. In this case, an appeal can be made, but it's not mandatory before you file a bad faith lawsuit in court. Insurance companies, on the other hand, which we just distinguished insurance companies from HMOs, insurance companies are regulated by the California Department of Insurance for the most part. There are a few exceptions. I know some of you probably have Blue Cross or Blue Shield policies that are individual policies but are regulated, or PPOs but are regulated by the Department of Managed Healthcare. However, that is not normally the case, but I'm just letting you know that there are exceptions. We have to review your policy in order to determine that for sure. In the case that the insurance company is regulated by the California Department of Insurance, then once again an appeal can be made, but it's not mandatory before you file a bad faith case. So even without making an appeal, you can submit a complaint to the court, and that's the beginning of your lawsuit. So what is bad faith? Bad faith is defined as an unreasonable conduct by the insurance company. So obviously it's very vague and very broad. Recovery in a bad faith case can include damages for breach of contract, which is, in the case of insurance companies, it means the money that is actually owed to you by the insurance company for claims that have been submitted that they have not paid. You can also recover damages for emotional distress, for punitive damages, which is are damages essentially to punish the insurance company for their actions, and you can recover attorney's fees. So now we're moving on to type 2, which is an ERISA claim. And these are policies that you get through your employer as part of an employee benefit plan. ERISA was enacted to protect the interests of employees that are covered under employee benefit plans. It technically stands for Employee Retirement Income Security Act of 1974, but within that whole act, there is all of this language about how these types of insurance policies work. So ERISA preempts state law, which means that if you file a lawsuit, an ERISA lawsuit in state court, it's subject to removal and generally is removed to federal court since ERISA claims arise under federal law. Government plans and church plans are exempt from ERISA, so that if you're a public school teacher, for instance, or you work at a church and you get your insurance policy through your employer, then those policies are exempt from ERISA, and those policies are treated like an individual insurance policy that we just talked about. Okay, so is anybody a government employee that has a question about that? Okay. So, in this case, ERISA remedies are limited to contractual damages, which are what the insurance company actually owes you, and reasonable attorney's fees. There are no punitive damages and no emotional distress damages. So, what is most critical about these ERISA plans is there is a mandatory appeal that's necessary prior to filing an ERISA lawsuit. And there's a 6-month time limit in which to appeal. So that is, in your insurance policy, it will actually generally say 180 days to appeal that decision. So if you have a denial of your claim, which means you get a written letter in the mail that states, you know, your claim has been denied for whatever reason, it doesn't matter what the reasoning is, you have 6 months from the date of that letter in which to appeal. If you don't appeal in that time period, you lose all of your rights to file a lawsuit in court. And so a lawsuit can only be filed after an appeal is denied. So you have to go through that appeal process if you have a policy that falls under ERISA. So, what is necessary when filing an ERISA appeal? The first thing that we do is we make a written demand from the insurance company for the administrative record or claim file. Now, the administrative record and claim file are terms that are used interchangeably, and it's basically the entire file that your insurance company has on you and your family. So, they have every claim that you've ever filed, every piece of correspondence that's ever, that you've ever written to them and that they've ever written to you. They should have notes of any phone calls that have been made to them and from them. They should have notes of any messages you left, any faxes that you've sent, anything that you have submitted to your insurance company or they've given to you should be in that administrative record or claim file. What is so important about this is the main set of documents that we use in order to file the appeal. And what's important for you to know about this is if you keep very good records of who you talk to, when you talk to them, what you speak with them about, and also if you send all correspondence to them, claims, via fax where you can get a receipt that your fax was sent, or via certified mail so that you have a return receipt. That is the best thing you can do, because if we see a claim file that seems to be missing documents, and we can prove that those documents were sent because you have that information, then that's a huge piece of evidence, essentially, against the insurance company when we're filing this type of appeal. So it's very important that you keep track of all of that information. And, even if you're just talking to somebody at customer service, that you say, what is your name? And generally they won't give you their last name, but that's okay. Just get their first name, note the phone number that you called to get, to that person, and get as much information as you can so that you have that all together. Next, we obtain letters, medical files, any doctor correspondence that can support the ERISA appeal. And basically, your doctors and care providers need to support the medical necessity of the care. Now, there are also other reasons that claims are denied, but for right now, medical necessity is the biggest reason that claims for ABA in particular are denied. So, the medical necessity needs to be supported in general by an MD. Psychologists can also support it, but it means more if it comes from an MD. As many of those letters as we can get, we will, and we submit those letters with the appeal. What is so important about having an attorney in this process is that you don't necessarily know what should be and should not be included in those doctors' letters, and the doctors don't necessarily know what should be included either. And there are certain there's certain language that we don't want to see in those doctors' letters because it could actually hurt you down the road. And so those are the things that we can help you to provide your doctors with sample letters that they can put on their letterhead and sign, which they appreciate as well because they're not being paid to help you with your insurance claims. So those are some of the reasons that it's very important to have an attorney reviewing those letters. We can also review the insurance policy and the plan information to determine whether the ERISA plan provides coverage, because obviously we want to know that there's coverage provided for before we appeal the claim. And we also want to be sure that the ERISA appeal is complete and contains everything that you want in order to show that there was improper conduct or bad faith where that's applicable. So we want to know, we basically want to know, did the insurance company talk to the providers prior to denying the claims? Was there a full and fair review of the claim? Those are the types of things that we need to see, that we need to review all these documents. That's the reason we request the claim file. Yes? Well, okay, this is one of the questions that comes up a lot. The diagnosis itself does not determine medical necessity. So the diagnosis of autism itself, whether your child's diagnosed with autism, Asperger's, whatever they're diagnosed with, does not automatically make ABA, for instance, or speech or OT medically necessary. However, if your insurance company decides that it is medically necessary and provides coverage of those claims, wonderful, perfect, you don't need us. But in the event that they deny those claims, that's when we have to go through this appeal process and get those doctor's letters to determine medical necessity. Okay? Yes? It's not that it's right or that it makes sense, but that's what they do. And I mean, there's differences between chemotherapy and cancer versus ABA and autism, only because when you're dealing with cancer, you're generally being treated only by medical doctors, which is one of the things that insurance companies tend to hang their hat on when they're saying that it's not medically necessary. Okay? Yes? Okay, so there is no legal definition of medical necessity. Medical necessity is sometimes defined in your insurance policy, but not always. And technically, it cannot be defined in your, or there's, an insurance company can't decide to define medical necessity in a certain way. And ultimately, that would be one of our arguments in a lawsuit about how they define medical necessity, but there's no legal definition for medical necessity. Yes? They should provide coverage for what is deemed medically necessary. So, obviously, you weren't filing claims for autism at the point when you didn't know he had autism. But the claims that are filed once you knew he had autism, then they should be providing coverage if your policy provides coverage for those services. But no, it shouldn't matter. It's not like, oh, well, you said he didn't have it before, so that shouldn't be an issue. Either they provide coverage or they don't. Coding is a huge deal, and not all codes work for all insurance companies, and some codes work for a certain insurance company for a certain time period, and then they switch up the coding, and when it comes down to it, there's no guarantee that any code is going to work or not work. Is it all in the coding? No, because it kind of depends who the claim specialist is that's determining whether they're going to accept or deny your claim. I'm sure it is. Now, I'm going to talk a little bit about the new laws that are coming into effect in July in a few minutes, but it is going to all change. Okay. So then, once we collect all the documents that we need for the appeal, we send the appeal to the plan fiduciary, which is determined by your insurance company. It is somebody at your insurance company. This appeal goes directly to your insurance company. It does not go to a judge. It doesn't go to a court. It goes directly to your insurance company, and they make a determination, generally within 60 days, of whether or not to accept or deny your appeal. Okay? And that plan fiduciary is noted in your insurance policy as to who that is and who you need to send those documents to. So, there is no hearing, no trial, no jury. There is no discovery process like you may have heard of when you file a lawsuit. So it is only the documents that you have submitted to the insurance company. In the event that you file a lawsuit, those are the only documents that will ultimately be reviewed by a judge. But for the appeal process itself, there's no hearing, no trial, no jury. State regulators are not involved because this is going directly to your insurance company. And if that appeal is denied, then you have the right to file a lawsuit in court, which will ultimately be removed to federal court. Yes?
Do you have any data on what percent of those claims or those appeals are denied?
No, because it's very policy specific. So it's hard to determine that because it really is dependent upon what your policy says. And just because, your friend over here has a United Healthcare policy that says that, they get 60 OT sessions per year, doesn't mean that your United Healthcare policy, even though if it's a PPO, just like your friend's policy, doesn't necessarily mean that you get those same number of sessions per year. There are hundreds of different PPO policies for every insurance company. There's hundreds of different HMO policies for every insurance company. So every policy is very different. The appeal process is different for every policy because it's a big portion of the appeal is obviously written towards your specific policy and the definitions in your specific policy. So if you file a lawsuit, once your appeal is denied, then once again, there's no jury, but there is a judge, and the judge makes the determination about whether or not what happens at that point, whether or not those services will be covered or not. It's generally based only on that record, which is the documents that you submitted in the appeal process, and there's no extra discovery or no extra information that you can provide at a later date. So it's really important that anything of importance is in that appeal, okay, that has to be filed within 6 months of the denial letter. If you're, so to kind of summarize what we just talked about, if your ERISA appeal is denied, you then have the ability to file an ERISA lawsuit in federal court, which requests contract damages and attorney's fees. And that's so long as you did the appeal within the 6-month time period. So the third type of policy is a self-funded policy. These are the types of policies that are given to you through your employer, but your employer actually funds the claims that you file, even though it may be administered by Blue Cross Blue Shield, United Healthcare, whoever. So the reason that I talk about self-funded policies is what's really important about them is they are not an insurance company, nor are they an HMO. So what's important about that is they are also not regulated by the laws that regulate insurance companies or HMOs. So your company, in the event that you have a self-funded policy, your company actually has the ability to determine what is covered and what is not. So it makes obtaining benefits difficult because they don't have the same regulations that insurance companies and HMOs do, and because you can't sue for bad faith, so you can't get punitive damages, you can only get the contract damages. And you can get attorney's fees if this type of policy falls under ERISA, which it generally would because it's generally a group plan. So it still is governed by ERISA, but you don't have those same appeal rights. Or you do have the same ERISA appeal rights, but you also have some other appeal rights that you may have through your own self-funded policy. Okay, so it's really important to know, that's why it's so important to know what type of policy that you have so that you know what your rights are. Okay? Does anybody have any questions at this point? Okay. I'm sure you guys have all heard of AB 88. It stands for California State Assembly Bill 88, or also known as the Mental Health Parity Law. So basically, it requires that health insurance companies provide coverage for the medically necessary treatment of severe mental illnesses of a person of any age under the same terms and conditions applied to other medical conditions. It is contained in the Health and Safety Code as well as the Insurance Code. So what does it mean to you? It means that if your child has autism or a related disorder, that their speech therapy, for instance, has to be provided at the same rate or the same number of times per year as the insurance company provides it for any other medical condition. Now, what it doesn't mean is it does not require coverage for any medically necessary treatment that's recommended by your treating doctor, but it means that the treatment has to be covered under the insurance plan for a different medical condition in order for AB 88 to apply to your child. So, for instance, if speech therapy is covered 60 times per year for a stroke victim, then it has to be covered 60 times per year for your child. If it's only covered 12 times per year for a stroke victim, it only has to be covered 12 times a year for your child. Yes?
Okay, so here's the 800-pound gorilla in the room. Since ABA is not typically used for any other medical condition other than autism, get where I'm going?
You asked the number one question. So ABA is rarely mentioned in an insurance policy. It's rarely mentioned as they cover it or that they don't cover it. It's generally not mentioned at all. So that is why it's so important to review the policies, because when we look at your policy to see whether or not an appeal makes sense or whether a lawsuit makes sense, we have to find something else in your policy to hang our hat on, essentially, for coverage of that ABA therapy. Okay?
Basically, it's not going to apply because even with AB 88.
AB 88 is very difficult to apply to ABA. That's correct. Because it's not used for any other medical condition. Exactly. So we have to find something else. It does, but the law is changing, so. Okay, so ERISA is a federal law, and it governs the group insurance policy. AB 88 still governs that same policy because your policy is actually a state-specific policy. So it's governed by state law as well as the federal ERISA law. If you have a California insurance policy, yes. There are times when you can work in California, but your company is based elsewhere that you may have an insurance policy governed by a different state. It's not common, but that can happen. So as long as you have a California-based insurance policy.
Question for you then.
Yes.
I actually work in Tempe, Arizona.
Okay.
But we live and reside here in California.
It depends where your policy is based, what law applies.
So how would I figure that out?
Like if you have, what insurance company do you have?
We have Cigna, so PPO.
Okay. So essentially, you know how you've heard of like Blue Cross of California? Okay, you want to make sure you have Cigna of California, not Cigna of Arizona. You just need to call them and find out. Or look at your policy booklet. If you have the policy booklet, it will say in there. But otherwise, if you have an Arizona policy, it's governed by Arizona law. It's not a whole different set of laws. Okay?
They have mandatory coverage in Arizona.
Mandatory coverage of
ABA.
So either way, you might be in a good position.
It's interesting because in Arizona they don't have the regional centers. And so, like here, his ABA is covered through the regional centers. But ABA, if we were to move and relocate out there, the ABA would have to fund go through the insurance company. So it puts a huge burden financially on parents because now I've got to pay not only deductibles.
Let's deal with that hypothetical at the end because we are going to talk about the interplay between regional center and insurance coverage.
But yeah, you need to find out if your policy is a California policy or an Arizona policy. Okay? Senate Bill 946. I'm sure you have all heard of it. It was signed into law in October, and it takes effect in July of this year. It is new law, so it does not apply yet. It will apply in July 1st of 2012. Your insurance company will be required to provide coverage for behavioral health treatment if deemed medically necessary. So we're back to the medical necessity that you were talking about. So we still have those same hurdles to jump, the same medical necessity hurdle. We need to make sure that that's taken care of. Insurance companies, all laws are subject to interpretation by the courts, and because there are no lawsuits based on this new law yet, we don't necessarily know what stance the courts will take. However, what I can guess is that insurance companies will still deny ABA. They can still deny it based on lack of medical necessity. They can deny it based on it being a learning disability. I'm just telling you the ways that I've seen it denied. Okay, so we all know that we can argue that it's not a learning disability, but I'm telling you the ways that I've seen that it's denied. So it can be denied on the basis that it's a learning disability and therefore not covered under the policy. It can be denied as experimental, although we don't see that nearly as often anymore. But they have all kinds of ways that they can choose to deny the coverage, and my best guess is that because this new law is going to be so expensive for them, that they are still going to do what they can to deny the coverage. I hope that they don't, and I hope that all of you get your ABA covered and it's no big deal and you file the claim and they send you a check, but my guess is that it's not going to be quite so simple. Yes?
I just had to run out. Did you speak as to why July 1st, 2014? Why does it end
Because that is the date that the Obamacare is supposed to take effect and take over what this new law is doing. So, but that's why there's an end date to this new law. Yes.
Quick question. Okay, so let's say that you do go to court and lose.
Yes.
Right? The cost is on you. Let's say you go to court and you win. Is the legal fee still on you?
Okay, yes, but your attorney's fees can be covered in some instances, like we talked about before. It depends what type of a claim you have. But it also, so if you can file a bad faith lawsuit, then if you have that ability, then generally an attorney will take that on a contingency fee basis, which means that there's no upfront cost to you in the event that you lose and you don't get any money. Then the attorney doesn't get any money either, except for costs like mailing and filing the complaint and things like that. In the event that you win, to use that term loosely, in the event that you win, then the attorney takes a percentage of the recovery. And attorney's fees, a lot of times we use things like punitive damages to kind of cover the attorney's fees. That's kind of the way that it all gets lumped together. You don't actually get like, you get this much in punitive damages, you get this much in attorney's fees, but it all kind of gets lumped together in the end, and the attorney takes a percentage of the complete recovery. Okay?
Isn't Kaiser being taken to court this October in a class action lawsuit regarding its practice of denying coverage to ADA therapists?
Yes, they are.
And what law would this be covered under, the 88 or 946?
Well, nothing's covered under 946 yet because it's not currently in effect.
Okay, so you have to fight it.
Yeah.
I'm unclear about that.
I think his question is on, do you know what the basis of the Kaiser lawsuit is?
I don't know, although I do know that it's similar to the Blue Cross and Blue Shield settlements that were. There was a Blue Shield settlement with the Department of Insurance very recently in January. There was a settlement with the Department of Managed Health Care back in July. Well, if they're being taken to court now, they're being taken to court on previous claims. So once this law takes effect, then they can be taken to court. If they continue to deny claims, they can be taken to court based on the new law. But currently, they can't be taken to court based on that because it's not in effect. Does that answer your question a little bit? Okay. Harlech versus Blue Shield. This is a recent, fairly recent court case. It was an ERISA case that was decided by the Ninth Circuit Court of Appeals. It determined that AB 88 provides benefits beyond the medically necessary outpatient services, inpatient hospital services, partial hospital services, and prescription drug benefits. So it was basically a case regarding anorexia and inpatient placement for an anorexic girl, and they did determine that AB 88 applied in that situation. So once again, we still have that medical necessity hurdle to jump, but this recent decision is helpful. Okay, so what can we do for you? First, we can give you a free 30-minute phone consultation, which you can ask any additional questions that don't get answered here tonight. We'd be happy to answer those questions for you during a phone consultation, and we can talk about your policy and any other questions you might have. We can also review your policy for a flat fee. It includes a review of the policy, the particulars of your specific policy, knowing what your rights are under your specific policy, knowing what your options are, and making sure you have options under that policy for whatever services you are looking to have covered. We can assist you with the initial filing of claims. If you would like assistance with those initial claim filings, we can do that. We can assist you with many appeal processes, whether it's through the insurance company itself, whether it's through the DMHC, the DOI, whether it's an ERISA appeal, which we do on an hourly basis, or whether it's a bad faith case, which can be on a contingency fee basis. And now I will take some questions. Yes. AB 88.
Probably between 12 and 15 years. It's been quite a while.
Yeah, I was going to say 10 to 15, so that, yeah. Okay. There are business cards, both mine and Bonnie's, up on the front table here. Okay. Yes. So that's what the Harlech versus Blue Shield case was, partially about. So yes, they can, and that decision definitely helps us in that area. Okay. Any other questions? Okay, I'm going to stay up here for a few minutes if you have any, more personal questions, I guess, that you want to ask me. But Bonnie is going to come up and say a few words.
So, how many people here have regional center eligible children or young adults? Okay. So, one of the things that you may have seen is that since the trailer bill took effect in 2009, insurance was added as a generic resource. And what that means is, just as for academic services, for example, the school district is the generic agency that the regional center directs you to for educational services. Now there's explicit language in the trailer bill that says if you need ABA services, you have to first come to us with a letter of denial from your insurance company showing us that you've tried to secure those benefits from your insurance company and been denied. Has anybody had that discussion yet? Okay. Well, we've had it a lot, and what I've seen is that the 21 regional centers are applying the policy differently. Surprise, surprise. And so I'd say sort of a general comment would be that in some regional centers where people already have ABA services and they've had them for a while, those people had been sort of more grandfathered in and left alone, whereas the enforcement has been more aggressive in terms of new families coming in. But what you're going to see now is that the regional centers are going to become much more aggressive about insisting that you give them an insurance denial before you can ask them to fund any ABA services for your child. And then secondarily, if you have existing ABA services through your regional center, they're actually going to, we're hearing, send people a letter that says, effective July 1, coverage for ABA services is mandatory under California law, and so, we're going to want to meet with you and see your proof that you have insurance and you've attempted to secure these benefits, and if you have them, we're not going to be able to provide these services anymore. So, that's one scenario. It's only really been playing out at 2 regional centers so far, but they've really stepped up the enforcement. And so up until now, to some extent, parents have been able to skate a little bit or put the issue off or come in with a denial that really, to me, if you look at it closely, isn't the product of very much hard work on the part of the parent to get the services from the insurance company. I think they're going to be asking for more. So that's one thing. This raises a lot of questions in terms of what happens to new people coming in, and then also people that have existing ABA services funded through their regional center. So for new people coming in, the way the law still should work is if you can demonstrate to your regional center that your child needs ABA services to develop his skills in all the non-academic areas that are covered by the Lanterman Act, whether it's communication, independence, activities of daily living, social skills, minimization of inappropriate and aggressive behaviors. Regional centers should still, while you're attempting to get that denial or that approval from your insurance company, they should be required to fund in the first instance. I don't think they're going to treat it that way, but that's the way that I think the law will still work. So that's point one. Point two, for people that have existing coverage, you will have all appeal rights if they come to you and say, we think we can stop providing this because you have or you should have insurance coverage. And so what that means is if you get a written notice of action and they tell you that they're going to end your ABA services because they believe you have insurance coverage, you must appeal that decision in fewer than 10 days in order to make sure that they don't cut your services off. The statute of limitations on the issue in general is 30 days. So if you want a hearing, you can wait until the 29th day to appeal. But if you want to have your services continue while the whole issue is being worked out between you and the regional center, between you and the regional center and an administrative law judge, you must appeal in writing within 10 days. So that's important. So, go ahead. So, do you have medical insurance? Okay. So, they can't require then obviously somebody else to pay for this. What you need is some help with your case, and you probably need an outside evaluation of your child. Without that, it's going to be very hard to get the hours up. The regional centers have a person called the client's rights advocate. That person is at least the first point of contact in terms of maybe getting some help for you with some of these questions. They usually can only take things so far, and most people, in order to get intensive, ABA services, whether it's through the school district or the regional center, they usually are going to need to work with an attorney or an advocate. But absent an evaluation by a psychologist or a neuropsych detailing why the child's needs are more intensive, they're going to be able to play that game with you, and sadly they're going to be able to find evaluators who are going to back them up. So going back to the question of insurance, the service coordinator who is assigned to your family, who helps you in theory obtain services for your child, is supposed to engage in something called service coordination. And historically, under the Lanterman Act, that has meant going to the school district with you in order to assist you in getting the services you need from the school district. Now, most people don't know about service coordination. They don't even understand that that's what the service coordinator is supposed to be doing. But they are supposed to help you go to whatever generic agency is responsible for providing the service and assist you with obtaining that service. So my question to the regional centers then is, fine, if you want parents to utilize their insurance, what kind of assistance are you going to give them in securing these resources? Do you have personnel at your agency that can help parents negotiate the insurance process, because it can be confusing? So that's something you might all want to take back to them. Yeah. Yeah. There's usually, sometimes it is referred to as a case carrier, but it's the person that does the meetings with you and your child. Yes. It depends on the need. You have to be able to show that there's a demonstrable need. But they're responsible for assisting the child or the person to achieve as normal a manner of adult living as possible. And so things which facilitate that development ought to be covered under the Lanterman Act. Obviously, if you can't socialize, it's very difficult to hold a job, go out into the family, marry, have children, and so on. So the short answer is if you can demonstrate that the child needs it, yes, they can be responsible for paying for it. Go ahead. Yes, you have to use one of their vendors, but they can always vendor someone who is not vendored. And I'll give you a little example. We've got a kiddo that's placed in a school in Utah called Logan River. He's residentially placed. The school district has refused so far to pay for that placement, and Regional Center has agreed to pay for this out-of-state placement, which is quite unusual, and we're quite happy about that. The placement is not vendored. Regional Center is assisting Logan River right now with going through the vendorization process. If they want to make it happen, they can make it happen in about 30 days. If Regional Center wants to make things happen, they can make things happen. Oh yeah, it takes two to tango. Absolutely, yeah. Bonnie Yates, no problem. Your question? You want to talk about Tempe, Arizona? No. We're going to talk about that too. How many hours a week? Okay. You should be getting between 10 and 25 hours. You should be getting between 10 and 25 hours a week through the Regional Center, in my opinion. Yeah. ERISA, yeah. Right. So they should keep paying all during that time. They should, and you have appeal rights, so if they won't, then you go to a judge and you can talk to the judge about what you think. I mean, they have to do it till you at least get to a hearing, and then the judge is going to decide at that point, well, I think that the families acted in good faith. They're doing everything they can to secure their benefits through insurance, and I'm going to set this for a status conference in 3 months, Regional Center. If family still hasn't, secured coverage, then, you're allowed to, initiate this process anew at that time. But yes, I think if the families had ABA services and can show a continuing need, and they're acting in good faith and doing what they can to get the services through the insurance company, then that's what is supposed to happen, and you shouldn't be punished for that, if that makes sense. Now, well, I think it's going to be helter-skelter. I think it's going to be every which way, because I think that different insurers are going to behave differently, and different regional centers are going to behave differently, and I don't know that, but we'll just have to see. But you raised another important point about how right now your ABA is essentially not costing you anything, except for maybe in, soul change. And you're going to be responsible if you get insurance coverage for paying the copay and the deductible. So here's what you need to know about that. Some regional centers have already begun negotiating with parents to pay for their copays. They're saying that they're only going to pay the regional center portion, so for like a kid that I have that we got school coverage and regional center coverage through insurance for, they're only going to pay for 15 of the 37 hours, but they're going to pay the copays. And the copays, the way the copays are looking right now, if you have 5 hours of ABA in a day, they charge that as like one visit, so there's a $20 charge per day. So this family has ABA, let's say 4 or 5 days a week through insurance, so their weekly cost is about $100. So $400 a month for their ABA. Regional center is going to pay for, you know, the 30% of that they think is their responsibility. Now, can you appeal that if you don't think that's a fair way to divvy it up? Absolutely. Can you ask them to pay for your annual deductible, which in many cases is going to be substantial? The answer to that is yes, but they're not going to voluntarily agree to do that without a bunch of discussion. And one of the arguments that we're hearing from them is that the deductible is for the whole family, or the deductible is for other services, so how do we prorate that? But the point is, they can do this if they want to. They're not going to do it unless you push them. But if they don't do it, what they're also occasioning the possibility of is it becomes infeasible potentially for you to afford insurance, and if you become uninsured, then guess what? They're back on the hook again. So penny foolish, pound wise. Let's see, pound wise, penny wise. Well, pound wise for regional center would be to say, we're going to cover the copays and we're going to, you know, look at the individual deductibles and see what a hardship they present, because like in your case, they're paying $750 a week for ABA services 52 weeks a year. So that's probably $35,000 a year. So if they even were to pay your deductible and pay your monthly cost for ABA, they would still be way ahead. So these are all issues that are on the horizon. We don't know what's going to happen with them. It's going to be regional center by regional center, and within those regional centers, it's going to be handled very differently depending on whether parents know what their rights are, or if they are unaware of what their rights are. So the last thing I wanted to leave you with is that insurance companies have historically taken the position that educational services can't be medically necessary. Therefore, any ABA that has to be provided in a community setting like a school setting must not be medically necessary. Our response to that is just because something has to occur in an educational setting doesn't mean it's not medically necessary. And so we are now beginning to see some cases in which we're getting coverage for children for ABA hours at school. So how do you make that argument? Well, you have to show that there are certain things that you have to be able to learn how to do in order to remediate the child's brain from the neurological condition of autism. And as you can imagine, it doesn't really work to teach certain kinds of skills in an isolated setting, and there's certain kinds of skills that are hard to teach in a community setting because the only community setting that children are in enough hours a week to practice things consistently is school. So the argument is being structured along the lines that, you know, executive functioning or communication or certain other types of skills are not academic skills, but they're skills we have to teach at school. And that's how those arguments are going to be made in the future. The last point is, if you this child, the one that we have the home and school coverage for, he's not having this problem because he's in a private school. But if you do get the ABA coverage and you're in a public school, we're going to have to convince the public school to let that aid in. And although historically public schools have been resistant to letting in aids funded by other people, we may see a softening of that position as resources continue to be scarce, and there's, you know, the possibility out there of, rather than paying a district aid $15 or $20 an hour, probably 15 or less than 15. I think LAUSD pays 13. They can have a free aid instead. So when we get to that point, there are arguments to be made about how to do this, how we could make it more comfortable for the school district by offering them certain kinds of waivers so that the school district wouldn't feel that the existence of the aid would be used in a due process hearing. So there's a lot of new areas on the horizon that I think are presented by this wonderful possibility for the first time of having large-scale coverage for ABA in California. And as somebody that has a 21-year-old, almost 22-year-old son who went all the way through an ABA program and was substantially remediated and is in college in another state now, what I can tell you is I've been watching this for a long time. I'm a lot older than most of you, but we all know that the insurance companies have gotten away with not paying their fair share, and I'm really looking forward to seeing what comes next. I hope it's going to be better. Okay. Well, they pay for what they call ABA, but they don't like to, and their programs generally, in my experience, would be a lot better if they trained their staff a lot more than they do. What I'm saying is, and this is my opinion, and I've gotten in trouble before for talking in political ways. So what I'm saying is, if you think you have the possibility of getting a better quality trained interventionist through insurance, and you were able to secure that, then there's a problem of will your school let this person in instead of using their own aid to provide what they call ABA. So, okay, go ahead. Does that make more sense now? Yeah. Yeah. Okay, well, ABA does involve collection of data. I think this is going to be the last question because we have to wrap up. ABA does involve... Okay, hold on. ABA does involve collection of data. The reason it does is because you want to see whether what you're doing and working with the child is effective. It sounds, though, as if what happened in your case is there was a lot of note-taking and not much teaching going on. And so when you work with a regional center or any agency or any school district, there's always a question of quality control in terms of the provider. And there are great providers and there are not so good providers. And I'm sorry you had a bad experience. And I would again suggest you probably need legal advice. Maybe you want to talk to the client rights advocate at your regional center. Okay. Can I answer one more question or no? Okay. Permission granted. Mm-hmm. What's your diagnosis? Yeah. There's no such thing as mild autism. Yeah, I mean, you need a proper diagnosis and then you need help. Mm-hmm. Mm-hmm. Okay, that's the kind of case, if you want to, there's probably a lot of lawyers that would be willing to look at it and give you an opinion for free about what they think you should do. It's hard to do that now in a public forum because there's a lot of facts and a lot of documents and things like that. But, you know, for those of you that feel as if you're not getting enough services for your children, there are research articles out there that talk about more or less, you know, what level of service is going to be adequate to aggressively remediate autism. And if you want those articles, I can direct them to you. But it sounds as if you've got a child that isn't getting enough services for the problem that he or she has. Yeah. Well, high functioning autism ain't, you know, you're the child's mother. You don't need me to tell you this, but high functioning autism isn't a walk in the park. Those kids need just as much help. It's just a different kind of help. Okay, I think in deference to the people that were kind enough to let us present, let me just kind of shut this down and we can talk to you for a minute up here. Thank you.